Okay. So, question. How do you stop child support from being taken out of your paycheck? Pause. My husband paid off his child support and asked our employer to stop taking it out of his check. But the CFO said he can't do that. Is that correct?
That's correct.
Can you expound, Mr.
I can.
Floyd?
So
Thank you.
there was an income withholding order that was issued. So the judge ordered his CFO to take the money out of his paycheck. To stop that, you need to get an order from the court terminating the income withholding order, and then he will be allowed to stop taking it out.
Is there something else that they need to do in order to make sure
That
the employer stops taking it out?
you should probably send it to the employer, the order terminating.
How do they do that?
You would do a request for issuance from the clerk's office and have them issue that order terminating support or terminating withholding to the employer.
Easy breezy. One
Lemon
point,
squeezy.
Mr. Floyd.
Done.
This is gonna be hard. Go ahead, Mr. Floyd.
All right. Question.
Okay.
Well, really statement
Okay.
with two question marks.
Okay.
I have different child care than the other parent. Do I pay for her child on her weeks? Pause. I have the children every other week. Provide and pay for child care.
What?
And
go ahead.
Provide and pay for child care. On my weeks, while I'm at school. Holy cow. Okay, so I think he's saying I have the children every other week and provide and pay for child care on my weeks while I'm at school. Do I have to provide child care for her weeks?
It depends. That's a typical lawyer chat. So number one, it depends on what your order says. And if you're required to enter the order, then yes. If it is silent, my typical advice is that during her period's possession, she has an affirmative obligation to provide for the care of the children, right? And so I would say that she is responsible for making sure that they have their own daycare, etc., during her time. However, sometimes I have these situations where the daycare is like, listen, she can't just come, or the kiddos can't come every other week, and if you want her here during your weeks, you have to pay during, for the entire month. And you can't make mom do that unless you maybe take her back to court and ask that the judge make her do that. And I don't know that a judge would actually give that to you. So yes, if you don't want to get kicked out of daycare. No, if it doesn't have an impact on daycare and it's not in your order.
Concur.
Easy breezy. 1 point. Shmee.
I didn't give you a point. You're going to give yourself a point.
I'm taking the points. Oh, shoot. Oh. My spouse moved to California about a year ago. I am in Texas. He filed for divorce in California. He is also fighting for primary for the kids. I am still in Texas. I do not have a ton of money. What options do I have to fight for this? Or fight this, rather. They don't say where the kids are.
Well, that's a problem.
Let's see. Should we say that... Let's go with the kids are in Texas.
Okay. So, and actually it doesn't really matter. It can and cannot matter. We'll go through it. So, the divorce, just the divorce can probably be done in California. We don't know California law, but if it was the same as Texas, they could do solely the divorce in California. They don't have personal jurisdiction over you, I wouldn't think, unless you meet some of the factors, which we're not going to go through. So they wouldn't be able to divide assets and things like that, but they could grant the divorce. And if the children are in Texas, California would not have jurisdiction over the children because Texas would be its home state. What was the next part of the question? Was that it?
Yeah, that's it. What options do I have to fight this?
Yeah, so if divorce is properly filed in California, you'd have to fight the divorce portion in California. Right, because it was the first place it was filed. I don't think you could argue convenience to the parties to get the divorce moved.
Mm-mm.
Right? Couldn't deal with the child custody issues in California. That's got to be dealt with in Texas.
So I think that it matters if there's a thing called personal jurisdiction, right? And so that's a way for the state to be able to grant affirmative relief as it pertains to a person and their property, right? And so let's say, hypothetically speaking, that mom had lived in California and then they moved to Texas and they were here for a few years, and then mom visited California and her family was there. Then there's this thing called long arm jurisdiction, which we need to do another podcast on all of that, Chandler.
Oh my God.
You're gonna be sick that day. And so if there's a way for the California courts to get personal jurisdiction over you, then they can divide up the assets. This is where I always get confused, because typically the code states that a suit affecting parent-child relationship shall be incorporated in a divorce proceeding.
Texas code says that.
Correct.
Right? But that differs from UCCJA's home state.
Right.
And so if one state, California, would have jurisdiction over the divorce but does not have home state per UCCJA over the child, the SAPSR still has to be done in Texas, and they can do the divorce in California.
Okay. And so what if
frogs had wings? Then they wouldn't bump their ass every time they jumped.
So what if the kids had resided in California?
For how long?
Let's say for a couple of years, but then they had been in Texas for more than a year.
So Texas would still have home state because it's the last place where they resided for a period of 6 months.
Okay.
Unless mom stole them from California and brought them to Texas in bad faith, then California could still get home state because Texas would have obtained home state by virtue of a bad act.
So, yeah, this person...
It doesn't say any of that in there.
From Austin, Texas, that asked this question on April 11, 2024, you need to hire a lawyer.
Yes. It can be complicated.
In California and in Texas, you can hire 2 lawyers. So good for you. But they don't have a whole lot of money to fight this, which really, really sucks, which is why strategically, I'm sure the father/husband did what he did, because there's certain pleadings that, assuming that you've never been to California, you have no ties or connections, that you have to file there, assuming that it's the same laws as Texas, so that they can't
Which is
get...
very unlikely given California.
True. To make sure that they can't get jurisdiction over you. So it is unfortunately important that you hire someone there, and then you also potentially hire someone here to file the requisite paperwork.
See. Yeah. And give us more facts. We can give better answers.
I think you get like half a point on that one. Go ahead, Mr. Floyd. Can you read this time properly?
You should have seen the verbiage in the last one. Weil was spelled W-A-I-L. Yeah, I know. Can I take my husband to court for not refinancing after divorce? My ex and I divorced and took my name off the deed of our home. In our divorce decree, it states he must refinance the home, and it's been over 2 years, and he has not refinanced the home. He has not refinanced the home. It's still showing up on my credit. Go.
Golly, Floyd. I feel like he had a really great attorney.
She got outmanned.
She did get outmanned. That's actually quite brilliant. So, mm,
I feel like you're getting 0 points thus far.
I'm thinking no. Can she take him back to court? That's the question.
I know that's the question for you.
Raise the question again.
Can I take my husband to court for not refinancing after divorce? I assume she means her ex-husband.
Right.
Not her current husband.
Right. And so it said 2 years for him to refinance. He didn't do it.
Yep.
Son of a gun. That was some good lawyering. So I'm going to go with no. Well, if they didn't do the paperwork properly, which they probably did not, even if there was a deed of trust to secure assumption, that wouldn't matter. Yes, no, that was bad. I don't think so. So here's my problem. Sorry, I'm struggling. I'm on the struggle bus right now. 2 years is your statute of limitations to file a motion for enforcement as it pertains to property. And so I think that in this particular situation, the statute of limitations would have passed. And so you would not be able to file an enforcement to hold him in contempt with regard to him not refinancing. I don't know that the court would even have jurisdiction over this after 2 years to even do anything. And it's not going to be a clarification.
Might be a clarification. I think that's the only way to try to do it. I don't know that you're successful, but in clarifying, a court can.
But they can't make a substantive change, so they can't say if you don't refinance, then it has to be sold.
But you can clarify provisions that would not be enforceable to make them enforceable. And so if the way it was drafted was he just has to refinance, there's no date by which he has to refinance.
2 years.
No, it's been over 2 years and he has not refinanced. It just says, in our divorce decree, it states he must refinance the home, and it's been over 2 years and he has not refinanced.
Okay, so I was thinking he had 2 years to refinance.
Yeah, don't think, just listen to the words.
Okay. So it's been over 2 years. There wasn't a deadline, so yeah, potentially. You think a clarification?
I think that's the only shot that you could try something, right?
Lord Jesus. And so this is why it's important to hire good attorneys who know this stuff. Because, so maybe, the answer is maybe, probably not likely. If you came in and consulted with us and you told me this fact pattern, I would tell you, listen, we would exercise best efforts, but I don't know that we're going to be successful, and I don't want you flushing a whole bunch of money down the drain, right? That's going to be very, very tough. Typically, what we do in these particular situations is we will incorporate a refinance by date certain. If no refinance, then residence is sold, right? And we have deadlines for when the residence is going to be sold. And if we are, doing a cash buyout, or excuse me, if you have some sort of equity interest in this home, we're putting what we call a ulti of partition on the entirety of the residence so that we can make sure that we're recovering your money and under the sale provisions. I understand, but I'm just saying this gives me anxiety. I'm not making anything up. I'm answering the question it's maybe, but there's stuff that you should do so that you're not in, what's her name? In Redford, North, or this is not even in Texas, but so that you're not in this particular situation, right? Make sure that all of this stuff is drafted appropriately in your final decree so you don't get screwed like this lady.
I agree.
Golly, Floyd, you're
0 points.
You're such a freaking grumpy old
If you had equity,
man.
She doesn't say anything about that.
It's helpful. People might have equity and might be in this situation. You're supposed to be providing information. You understand.
Well, of course, you go down a whole trail of shit.
You're making me sit on myself. That's how freaking frustrated I am with you. Okay. Ooh.
That's why the last one took an hour.
Okay. This is a long question, so be ready for it. Do I have to share my retirement, even though my husband purposely blows all of his constantly, and I will not get anything from him? My husband represents himself in our divorce and has an order of protection on him, so I assume a protective order. My attorney said I will likely have to share my retirement with him, even though my husband has been blowing his money / retirement left and right, meaning nothing coming from him to me, but a big chunk of mine going to him. There's a trial coming up, and the judge will decide soon. Would I be better off financially withdrawing the divorce? Thank you.
You're welcome. Depends. So it depends on, one, how much money we're talking about. So generally speaking, just and right division court started at 50-50. Depending on what he's been spending his money on, right, you may be able to request a disproportionate division based on, waste or any type of fraud claim, something like that, breach of
There's
fiduciary.
nothing in the fact pattern, Floyd, about waste or fraud.
Yes, there is. He's been blowing his money. That means not on
so
good
it's
things.
okay. We can consider other factors because this is informational,
It says he's
right?
blowing his money. Assuming blowing means wasting.
You don't know. He could be blowing it on shelter and food and medical expenses.
Is that blowing or spending?
It may be, in her opinion.
No, absolutely. Blowing is.
You don't know what she means by the term blowing.
I do too.
You don't. Go ahead.
So, since you said blowing and not spending, I assume he's wasting
because you're trying to make a point.
No, because blowing means spending it frivolously, and possibly a breach of fiduciary duty as well. So you can request disproportionate division based on that, and so you may not get as much of your 401k. And whether or not to continue the divorce, I don't know. Depends on what it's worth to you to be divorced, I guess, and how much money we're talking about.
What do you mean you don't? Don't you think, yes, she should still proceed with the divorce? Because if she doesn't, what continues to happen?
Well, the 401k continues to grow, but I had this very situation not long ago and told that person.
So would she be better off financially withdrawing the divorce?
So if you do withdraw the divorce, your 401k will continue to grow. And if something should happen to you, it all go to him. Right? Whereas if you continue with the divorce, although you may be giving him X number of dollars, at least you know that this is yours, and if something happens to you, it goes to your peeps, not his. So I think that's something you need to sit down privately with your attorney under the guides of privileged information and discuss how that would work for you.
And if in fact he's blowing his money, and if it really is like he's, going to Vegas and
which we know it is because you said blowing, not spending.
And so if he's doing that, keep in mind that those fraud and waste claims are very time consuming. They're very difficult to prove up. It's going to cost you lots of money in attorney's fees to be able to establish it. But if you do, kind of the premise is if he blew $100,000 on just random crap that he didn't need to blow it on, then $50,000 of that was yours, and so you can fight for that $50,000 to say, listen, I should have $50,000 in his 401k, but he blew it, and so
spent it.
I want to keep the additional $50,000 from my 401k. So easy, breezy.
But the answer might be no. Question. Divorce without knowing?
Okay.
Husband divorced me after I was served. He told me he stopped legal proceedings, but was telling his attorney that he wanted to proceed and didn't know my whereabouts. We were reconciled. This sounds familiar.
Mm-hmm.
This is in Houston, Texas, not ours. We have a 3-year-old. We were divorced in Feb, but I only found out in April. Is there anything I can do? Period.
Yes. So they were divorced in February and she found out in April. So she's past the deadline to file a motion for new trial. Although, Floyd, isn't it, there's an exception that it's from the time that you learn of it, right?
Okay. Divorce without knowing, question mark. Husband divorced me after I was served. He told me he stopped the legal proceedings, but was telling his attorney that he wanted to proceed and did not know my whereabouts. We were reconciled. This was in Houston. We have a 3-year-old. We were divorced in February. I found out about it in April. Is there anything I can do?
So you'll have to file what we call a bill of review. Okay, so typically, if you find out the stuff within 30 days, you can file a motion for new trial. And so there have been times where we have been hired like on the 27th day, and we are hauling tail to get this motion for new trial filed before the expiration of those 30 days. But on the occasions where, similar to this, we've had this happen also, where the client finds out after the 30-day time period to file the motion for new trial, your only remedy is going to be a bill of review. And in that, you essentially allege, kind of what happened to you here. There's, certain pleadings that we'd have to file. You would have a hearing, and then at that particular point, the court could set aside that judgment. And if they set it aside, then it's kind of like you start the whole divorce proceeding again. The deadline for that is 4 years. So you have 4 years from rendition of judgment to be able to file that. So, and there's certain elements which I can't remember offhand, but I think under this fact pattern, you probably have success with that.
Concur.
Easy breezy. Okay. So can I sue my soon-to-be ex-wife? She lied about everything. She lied about her parents dying, her being a nurse, and her kids being adopted. She was supposed to pay the rent, almost had me kicked out of my crib, made payment arrangements by acting like she was me in court. I found out she was not paying rent the day she packed all her stuff and moved out. I owed $8,500, maxed out my credit cards. I have not heard from her since.
I don't know. So this would be more along the lines of civil litigation towards stuff, but certainly you could probably get away with the breach of fiduciary duty, right? She had a duty to care for the assets of the marriage. Since it's only talking about lawsuits, I don't really want to get into the remedies available in a divorce. I guess I can.
Yeah, I mean, that's a lawsuit.
Yeah, so you could claim probably waste, fraud, and request a disproportionate division of the marital estate based on those. Anything else?
I think that's it.
Yeah. So, yes.
Easy breezy. You're such a jerk. Go ahead, I'm ready.
If my spouse owned an LLC prior to the marriage and the business earned income during our marriage, is that income community property? Then she clarifies, if my spouse owned an LLC before the marriage and the business earned income during the marriage, is that income community property? She says
Yes.
I think twice.
Yeah. If it's income of the LLC, well, and I guess, presuming that it was actually dispersed and earned
That's
by...
quite a presumption there, Miss Jimenez.
I always presume I just like building little facts in my little brain. Like, this is how it's going to go. Typically, I would be asking clarifying questions if I was doing the consultation. So assuming that those funds had been dispersed to the husband, do we know that this is a husband or wife? No?
We know it's a spouse.
Okay, it had been dispersed to the spouse, then that is community property. You have rights. So, like, it's in your personal checking account or your joint checking account or whatever, right? That's subject to division. If not, then no. It hasn't been dispersed. Yeah, no ish. I just think no. How?
Well, so for example, let's say that the LLC is separate property.
Mm-hmm.
It's profiting $500,000 a year.
Mm-hmm.
He takes a salary of $5,000 a year,
Mm-hmm.
so that the separate property continues to grow. You may be able to pierce the veil, some type of fraud that he's intentionally keeping that money away, spending her money or something instead of paying himself a fair, reasonable wage.
Okay,
A little more difficult,
I like
but
it. But if he was paying himself reasonable, earnings, and you guys had been using it, I think that might be a tough sell.
see.
Easy breezy. Okay. Good questions, Chandler.
Ish.
Good questions. As always, thank you guys so much for listening to us, for watching us. We appreciate the support. Find us on any social media platform that exists: TikTok, Instagram, Facebook, YouTube. Like and subscribe. Again, this is not to be construed as legal advice. Find yourself a good attorney that you feel comfortable with. Tell them your story and then listen to them.